Welcome to Chat with the Lawyer. I'm your host, Walla Blagay, and today we're honored to have Attorney Jibril Brown from the law offices of Garland C. Hall. And we are bringing him on in response to your request. Many viewers have reached out to us about child support enforcement and how they wanted to know more information about that. So we went out and found a great lawyer to give us great advice. So Attorney Brown, welcome.
Okay, thank you. Honored to be on the show. I thank you for allowing me to speak.
So tell us about yourself. Like, how did you get into the practice that you're in now?
It kind of sort of just fell in my lap. I had a couple of cases. A couple people said he seems to be knowledgeable, and sort of word of mouth.
Okay, and what type of law do you practice overall at your law firm?
Primarily domestic, child support, child custody, divorces, everything that goes along with that, bankruptcy, criminal defense, little personal injury, no med mal, car accidents.
Wow, so you jack of all, you know it all.
I try.
So let's jump right into it because this has been a really important topic. Many people have contacted us because they have gotten, it's been two sides. So let's start with the one side. The one side is somebody who's like, look, child support has come and they're taking away $1,500 out of my paycheck. I can't afford to live. How did this happen? I need a lawyer to help me out, to get me out of this. Now, how does someone get to that point where child support is taking so much that they can't really live?
Well,
so let's go over, like, how does it get to that point? Guide us there.
Okay. Well, if I would ask the individual to see what his or her income is, and with respect to the primary custodial parent's income is, because Maryland.
So how do they come up with the income guidelines anyway?
Okay. Well, Maryland has a set schedule. Okay, so the Maryland legislature, the General Assembly has said that essentially, it said that a party making X amount of dollars, right, per month should be allocating X amount of dollars to the support of their children.
And when you say X amount of dollars, is there a certain percentage that you can just say out right now?
No, but just to run through it, if I can really quickly. Okay, so Maryland takes the party if they're a W-2 wage earner. Okay, so we're going to talk to people who are employees.
W-2 wage earner means what? You're just getting a regular paycheck every 2 weeks?
Yes, you go to work, your employer pays you, takes your taxes, etc. Okay, so Maryland takes both parties what's called adjusted gross income. The adjusted gross income is the income minus the four things that your employer has to take out: state taxes, federal taxes, OSDI, OA, Social Security. There's another one. So,
right, and just to clarify, you can see your adjusted income on your tax return, right? On your taxes, it says adjusted gross income, right?
No, the adjusted gross income is what the Maryland legislature has said to get your gross income, because that's not your net. Because your net on your from your employer could include retirement, any union fees or dues, anything like that. But Maryland says that these are the four things that we're going to take from your gross income. These are the four things we're going to take from your gross, and then we're going to take both parties' gross income. Okay, so we take mom's gross income, dad's gross income. Combine those two numbers together, we get a sum, right? So with that sum, then the Maryland General Assembly says that we're going to take the ratio of that sum. So we're going to take the percentage of that sum, and then that's the amount of money that the non-custodial parents pay. Okay, so if we plug in some numbers, okay, so let's just say we have two parties. Let's say mom's adjusted gross income is $66, right? Dad's gross income is $33, right? Mm-hmm. Okay, so you combine those two together, we have a sum of $99, right? So Maryland says, okay, well, a party making $99 a month should be allocating $50, right, to the support of their children. Okay, so then the court will take. Actually, no. Let's just back up because I can use some more round numbers. Okay, so let's say that mom makes $666, dad makes $300. $33, right? You combine that together, we have a sum of $1,000. So Maryland says that a party making $1,000 a month should be allocating $100 a month to the support of their child, right? So then Maryland takes the ratio of the sum, and under the ratio that we had, mom would be responsible for 66% of that $100. So mom would be responsible for $66. Dad would be responsible for $33 the change. Okay, and the child support is always paid from the non-custodial parent to the custodial parent. So under that scenario, dad would be paying mom $33 per month. Mom doesn't have to pay anything because it's already implied that she's going to be paying the $66 because she's the primary caretaker. Okay, so now we take the same scenario. The same scenario, mom makes $333 and X amount of change, right? Dad makes $666 and some change, okay? In this particular scenario, mom is going to be responsible for 33% of the $100. So mom's going to be responsible for $33, blah, 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 blah. Dad's going to be responsible for $66 and the change. So in the second scenario, dad's going to be paying mom $66 per month. That's how it works. So to sum it all up, Maryland says that a party making X amount of income combined, their gross income should be allocated X amount of dollars per month.
So it's the percentage of what you make in the adjusted gross income, which is the sum. It's a percentage of that that determines who pays, how much you pay.
Yes, how much you pay.
Okay, so let me ask you a question. If somebody, let's just say, so the non-custodial parent comes to you and says, there's been a miscalculation here because I have to pay this much money and I can't really afford it. As a lawyer, what do lawyers do? How do they help in that situation?
If they think that there's a miscalculation, when we're talking about child support, it's never really permanent in the permanent sense. I like to say it's final, but it's not permanent. Okay, because when I say it's final, it's done. But if there's anything that comes along, but when the court uses the term material change circumstances, if there's material change in circumstances in either party's income, either party can come back to the court and say, we should revisit this matter and recalculate the child support.
Okay, so given, let's just say I am, as you said, a W-2 person where I get the same amount every month. And I say, well, I can't really afford that. If there's no other circumstances, I'm just like, look, I can't really pay this based on all my other bills. I can't really pay this, but there's no substantial change. So is it given that it might be nothing that can be done?
Well, I would stay from the blank statement, nothing can be done. At that particular point, you probably should get an attorney because in most areas of law, there's always some exception, okay? Now, these exceptions are not the norm, that's why they're exceptions. But in the proper circumstance, if it is too much of a hardship or burden, you can make the argument to the court. The court doesn't have to accept it, but you can always argue that there should be, in certain circumstances, a downward deviation or an upward deviation. Now, there's factors that the court has to go to, which means that the moving party has to present those factors to the court for the court to consider whether or not an upward deviation or a downward deviation would be in the best interest of the child. Because ultimately, that's what the court's going to be concerned with, is the best interest of the child.
Now, so then on the other side, what if you're a business owner who is steadily, who your income every month varies depending on how much, business you get?
In that particular circumstance, what the court will probably do is take the average, the average, because like you're saying, like, okay, so you have a business, you have peaks and you have troughs, and then there's the little gray areas. So in those particular circumstances, the court will just average the yearly income.
Okay, all right. So then it will still be determined on an average. Now, could it be? What if you're a business owner that maybe the last few years were good, but this year has been really slow? So the average of the last few years is still above what you can pay now. How would you address that?
Well, in that particular circumstance, if it's a substantial variation, if it's a substantial variation, then the proper thing to do in that particular circumstance is go back to the court and ask for a modification. saying I was making this much money last year. This year I'm projected to make this much.
Or based on what I've been making for the last few months.
Correct.
I see. Okay. So on the other hand, let's just say the person who is the custodial parent thinks that there's some fraudulent reasons. Like, of course, the non-custodial parent says, "Oh, I can't pay this. This is just too much," and the custodial parent feels that there is some fraud in their response, or that basically they're not telling the truth. How should they deal with that?
Well, in that particular circumstances, when you go to court, it's all about proof. So if you believe there's fraud, you're going to do your homework. You're going to have to investigate. If you have an attorney, he or she will engage in discovery. The two most commonly used ones in these types of circumstances is interrogatories, which is a big fancy word for a set of questions, and request for production of documents, ask on the side for documents. What you can do is, if you don't believe the answers or you don't believe the documents, that particular person's attorney has subpoena power, so the attorney can verify the documents that have been submitted. And if those documents turn out to be in variance with what the party has submitted, well, then you present it to the court, and then you have corroborated your suspicions of fraud or misrepresentation.
Now, what if the custodial parent has not been receiving any money from the non-custodial parent and child support? What do you do then as a lawyer assisting clients?
If they're not receiving child support, in this particular scenario, is the non-custodial parent working, or?
I mean, is that some of the things that you go through? What if they are not working? What happens then?
The old adage goes, you cannot get blood from a turnip. So if they're not working, you probably can't get anything. That does not absolve the non-custodial parent of his or her responsibility to support their child. Because if that was the case, some people may just stop working. But if, with respect to enforcement, there's a couple of ways to enforce child support. One, the easiest one is the wage attachment. So what will happen is
Can you just explain the wage attachment?
Okay. A wage attachment is when the court says that you're going to pay X amount of dollars per month. That particular order is then sent to the other side's employer, and their employer will take the ordered amount of child support. And depending on how the person gets paid, it'll be broken up in those percentages. So if the person gets paid bi-weekly, then they will pay half first pay period, half second pay period. If they were paid weekly, then they'll pay 25, 25, 25, and 25. That's one of the more easier ways. Then, with respect, that's with collecting current child support. There's a little, if we're talking about back child support, what I advise clients to do sometimes is to get a judgment, and then you can start collecting on the judgment.
Okay, and how would they get a judgment? You
would make the proper application with the court, asking that the child support arrears be reduced to a judgment, and then once you have a judgment, then there are other enforcement mechanisms that are available to you.
All right. Well, we're going to take a short break, but we've gotten a lot of good information from you, and we want to dig deep into sort of what the problems you see as an attorney.
Mother hasn't paid the bills in months.
My parents try to keep their financial mistakes hidden from me.
Mom paid the bills but mailed them to the wrong place again.
Dad couldn't figure out the tip for the pizza delivery.
Have you noticed a decline in your aging parents or loved ones when it comes to money or financial decisions? As we age, our ability to make good financial choices decreases. Starting a conversation about this with a loved one or parent can often be hard.
I know my mom is having difficulty, but how can I help her?
SmartAboutMoney.org offers tools and self-directed courses for starting the conversation and planning for the future. Smart About Money is committed to educating Americans on financial topics and empowering them to make positive and sound decisions with their finances. For help with family financial planning, visit the free money experts at smartaboutmoney.org, a non-commercial organization focused on your financial success.
Welcome back to Chat with a Lawyer, and we're here with Attorney Brown talking about child support enforcement, a very important issue. After viewers like you have reached out to us. So let's go back into it. What are some of the major issues that you see in your practice when it comes to child support that you want to advise us on?
I would like for everybody to know that when you go to court, whatever documentation or proofs that you have, to bring them to court with you. Okay, that's what I always tell, I don't always tell, but I advise people is that court is an arena of proof. So if you have any documentation and you want to get credit for it, you need to bring it to court.
So what are the documentation that you feel that people are missing? Give examples.
One, if you're the custodial parent, then the child is of actually of age where you need work-related child care expenses, so daycare receipts. That's very important because if you want to get credit for it in court, you're going to have to show an invoice or a bill paid. Also, who's paying the medical insurance for the child. Any extraordinary medical expenses, that's anything over $100 a month. So if you want to get credit for those things, you need to bring them to court. Another issue I see is sometimes with the non-custodial parent. The non-custodial parent may have a child from a prior relationship, and he or she may be paying child support for that child that's in another relationship, from another relationship. But if you want to get credit with the court, you have to bring in documentation showing that you're paying X amount of dollars per month for that child is not the subject of that particular proceeding. And also, some people seem to, I've heard clients in the past say, well, it's not court ordered. I'm paying child support, but it's not court ordered, and can I still get credit for that? The answer to that is yes. As long as the statute says child support actually paid. So if you can show the court that you're paying the parent from your other relationship X amount of dollars per month, then you should get credit for that.
So one of the issues that comes up often that people have complained about is about who's considered the custodial parent. There's a movement of mostly males actually, and they've come on our show actually talking about the shared parenting model. Basically, there's a discussion of a bias of the court to give custody to the mother. And that basically if you change the legal standard, meaning the presumption of shared parenting where both parents get custody, and then that allows there to be a sharing of custody and maybe unburden some of the males that feel that they always have to pay child support and they don't get as much access to their child. So what is your take on that?
Well, with respect to the presumption, there is no maternal preference in Maryland. Because actually, if there was a maternal preference or a paternal preference, that would probably be unconstitutional because then you have a preference for a particular sex over another, which is unconstitutional. What the court does is the court takes a list of factors when it comes to deciding who should be the primary custodial parent. So when you go to court, you have to articulate and express to the court what factors you played a heavier role in. And that's how the court makes a determination as to who should be the primary custodial parents, not just because it's mom. It's a list of factors. There's a case called Taylor v. Taylor that has majority of the custody factors in it. That's what the court uses to make its determination as to who's going to be the primary custodial parent. It's not just because mom is mom. She's automatically the primary custodial parent.
Now, do you, in most of the cases that you encounter, do you find that it's pretty equal of who gets the custody, that it could be either dad or mom, or do you find that it's mom 75% of the time?
I don't know if I've actually at a position to make a
assessment at this point?
Yes, because I haven't actually tallied up all the numbers.
Okay, but for the most part, can you say it's most, I mean, you don't need to tally, just from your recollection, do you think it's equal, or do you think it leads one side or the other?
I don't think it necessarily leads to one side. I think that where some men get frustrated is because when parties get together, sometimes they sort of, without saying it, they sort of merge into the gender roles. For whatever reason, I would say a fair amount of time, mom is the one who does the cooking, bathing the child, feeding the child, etc. And that's one of the factors the court looks at. Who was the actual primary caretaker of the child? Doesn't necessarily mean that dad didn't do anything, but the court says who did majority of the caretaking functions. So if, for whatever reason, the parties have fallen into gender roles, even though they may not have actually explicitly said it, it just happens because they're together and they're working as a team. If mom was the individual primarily doing that, well, then she will probably have a better footing when they go to court. I've seen it the opposite way as well. Now, if for whatever reason, let's say mom has a really demanding job, and dad is the one who takes off work, or his job is a little bit more liberal for schedule, all right? So in that particular case, dad would be doing most of the caretaking functions, and in that particular case, dad would probably have a leg up in court. But I think that it's somewhat conflated when men said that mom automatically has it. It's not necessarily that mom has it. It's who, prior to the court, who was doing majority of the caretaking functions, because a good percentage of the factors are caretaking functions.
Okay, so one of the things is that, again, I talked about the shared parenting role. So what if we did change the standard and that the standard goes into shared custody first? And the only way that it won't be shared custody is if somebody is able to prove that the other is not fit to have custody at all. So how would that, do you think that that would change the structure of the child support or just custody battle?
Well, I think the majority of the judges, I mean, the law actually already says is that we try to give both parties as much time as practically feasible given the particulars of their case. If both parties are perfectly fit, I, in my travels, have seen judges actually do a 50-50 somewhat. But I would caution everyone that when you say 50-50 or somewhere near 50-50, it has to be feasible. When I say feasible, it may not work if the parties live in separate school districts, or it may not work if one party lives in Northern Virginia and the other party lives in Suitland. Even though those two locales aren't that far away, but when you factor in getting the child to school in the morning, we all know how traffic is in the morning on 495. So in that particular case, even though the court may want to, the court may not be able to, because the court ultimately has looked at what's in the best interest of the child, and that is the focus, is what is in the best interest of the child. Now, if both parties live in, let's say, in the same school district, or one party lives in another school district, and the difference between wake-up times from each party's house is maybe 15, 20 minutes, court will probably maybe more inclined to actually say 50-50. Then you also have to look at other factors like what is the demands of that particular party's work schedule. Like, let's say one party is a physician and he or she is on call at night. Is that particular party actually in a position for 50-50? So there's a lot of variables that go into it versus just saying, I just want 50-50. I think that most judges, if the situation presents itself, they have no problem awarding a 50-50 type custody arrangement.
I see. So with custody issues in general, many have argued that when they go to court, they lose custody or limited custody, it doesn't work out for them, and then they look to lawyers. Can lawyers really help change that, and how would you if you're involved in that process? For those who have custody problems and want to get sort of a change in custody, because many go through the legal process of custody and come out very frustrated.
Well, I would say that in most situations, if you're going to go to court, I think a lawyer is very, very beneficial and helpful. As I said before, with respect to custody, it is final, but it is not permanent. So what that means is if there's something that affects the welfare of the child, you can always petition the court and say, I want to revisit this particular custody arrangement. So, and what counts as a material change in circumstances, once again, is that gray area where lawyers play around in. What may be a material change in circumstances of case A may not necessarily be a material change in circumstances in case B. And I think that with an attorney can help you pick out what may be a material change of circumstances if there is a material change circumstances present.
Give us an example of material change circumstance, because if the person doesn't, let's just say they have no real changes, they just don't like the way, at this point, they have no access to their child, and they're very frustrated about it, but there's no real material change from the actual trial. Is there anything that can be done? What has to change in order for them to really get a change in the custody, in the outcome of custody?
Okay, well, if a party's not getting any access, that's a huge problem. I say access, I mean visitation. Okay, so if a party's not getting any access and there's an order that says that you should get some access, there's also a mechanism for that. You can file a petition for contempt with the court. The court will look at that contempt, and if the party was wrongfully withheld the child and/or children, then you may get some makeup time. In the event that it is of a magnitude that is extremely egregious, that may be a material change in circumstance for the court to revisit the entire custody schedule. So if a party is not getting any access, and it happens maybe over a period of time, and it is not just a once or twice type deal or arrangement, a court can say, maybe you're not the proper party to have primary custodial custody because you're abusing it. So if in the more egregious circumstances, denial of visitation can be a material change circumstances. That's why it's important to consult with a lawyer, because he or she will be better able to advise on whether or not that amounts to material change circumstances.
So if somebody wants to contact you because they do have issues with child support custody, how do they contact you?
Okay. You can contact me at the law office of Garland C. Hall. The phone number is 410-787-0007.
And do you have an email that they can contact you?
I prefer the phone
call?
Because I don't really check my emails.
Well, good. At least you're honest.
If it's really important, my secretary, she will buzz me numerous times.
Well, thank you for coming on the show. We really appreciate you. And as viewers, you see, we have listened to you, and we've had this attorney come out. And if you have other issues that you want us to address, contact us at chatwiththelawyer, www.chatwiththelawyer.tv. And thank you for joining us.
Hi, I'm Matt Martin, and in all my years of playing professional hockey, I've gotten my share of bruises and injuries. But for many who really put their lives on the line every day, it's not always the injuries you can see that hurt the most. I'm talking about our veterans. Every single day, 184 veterans are diagnosed with post-traumatic stress, and tragically, 20 take their own lives. When medications and therapy don't help, professionally trained service dogs can. American Humane, serving the U.S. military for over 100 years, has put together a free guide to help veterans obtain these life-saving service animals. If you are a veteran or know a veteran struggling with PTS, please go to AmericanHumane.org for this free, downloadable resource. Let's give our veterans the help they need to win their battle.
From the moment that ordinary colonists took up arms for liberty, people from all walks of life expected to serve during times of war. But then the draft ended, and since, less and less of us have any real connection to the armed services. What is lost when we replace civilian soldiers with professional warriors? And what happens when stereotypes harden about what it means to serve our country? Help begin to bridge the military-civilian divide.